live from Houston, Texas, every Tuesday from 5 p.m. Central Time to 6 p.m. Central Time. Along with me is my business partner, Emily Neiman. Emily, what do we have today to discuss?
Well, last week, the Department of Homeland Security finally came out with the long awaited F-1 student visa regulation that really changes what it looks like to be an international student in the US going forward. So, if you are currently in the US in F-1 already, you may be wondering whether this new regulation applies to you, when it takes effect, what it means for your status, travel, OPT, future extensions, change of program, change of study, all of that. We'll walk through those common questions that we're receiving and kind of explain what current students need to be watching out for. We'll also talk about H-1B wage levels. USCIS is definitely paying more attention to the wage level listed in the petition, verifying that it matches the experience, the duties, the seniority, the supervisory skills mentioned in the I-129 form and in the filing with the letter of support. And when those pieces don't really line up, employers can face questions, sometimes revocation, sometimes notice of intent to deny or requests for evidence. We're definitely seeing that on some of the H-1B cap filings this year. So we'll discuss those common problems we see and what employers should be doing and what H-1B workers should be doing to reduce that risk. We'll also talk about remote work. It's obviously more common than it's been in the past, especially post COVID. But the H-1B compliance rules were really designed way before COVID, when remote work was very rare and definitely not a permanent work from home arrangement in most situations. So now, if an employee is working from home office, in their bedroom, another location that's not listed in the original petition, when is an amendment required? What steps need to be taken for the LCA, notice of filing? And that really depends on where the worker is actually physically working and how that location was addressed in the H-1B filing. So we'll talk about when the amendment is required. And lastly, with the new policy, relatively new policy, vetting social media for certain visa categories who are applying for their visa stamp, a lot of applicants start kind of reviewing their years of social media posts and wonder whether they need to delete things or make their accounts private or stop posting and all of that. So we'll talk about kind of issues we've seen with people going for visa stamping and why making drastic last minute changes on their social media accounts might actually create more problems.
Emily, there is a complete overall of the F1 regulations right now. And the start date for the F1 is that from September 15th onwards, anybody who is entering into United States will not be given duration status. They will be given based on their I-20 expiration date. They'll be given based on based on their OPT, based on their STEM extension. Their expiration date will be limited. But there are a lot of people, there are like 300,000 plus international, or 400,000, 500,000 international students right now existing in the United States. So let's only ask the frequently asked questions that normally people go through only for the people who are in United States. I'm going to ask some questions and I want you to ask some questions. Emily, so everybody knows that from September 15th onwards, anybody who is entering into is called, they will give a limited duration. For the existing students, though, do they need to do anything proactively for if they are just going to school, or if their OPT is still valid, if their STEM extension is still valid? Do they need to do anything before September 15, 2026?
No, that September 15th date is the effective date of the rule, but it's not a universal expiration date for every student who's already here. There are some transition rules that we'll talk about. But for most people, they do not need to do anything before September 15th due to that rule taking effect.
My OPT is valid until my OPT is valid until June 2027. Can I continue working until June 2027? Do I need to take any action on OPT?
Yes, if your OPT is already approved, you do not have to take any action. You can continue working till June 2027 based on that OPT.
Same thing with STEM extension, I was assuming, Emily?
Correct. Yeah.
Okay. You go and ask, Emily.
All right. So Does the visa stamp have anything to do with this September 15th, 2026 deadline? And do I need to do anything if my visa stamp is expiring?
Even if the visa stamping is expiring in August of 2026, you don't have to do anything at this point of time, Emily. Emily, if I am applying for the OPT, there are rules right now, deadlines, where I need to file an I-539 form if I file it before or afterwards. For those people who are filing an OPT or STEM extension right now, they get an I-20 endorsed and they are going to file the I-765 form. When is that they have to file an I-539 form, Emily?
If you are going to be filing your I-765 for either your OPT or your STEM extension after March 18th, 2027, then you need to also include an I-539 application. So if your OPT or STEM OPT is already filed and currently pending before September 15th, you don't have to do anything. If you file your OPT or STEM OPT between September and March, you don't have to do anything special. But after March 18th, you have to include an I-539.
Emily, I have completed my master's degree before September 15, 2026. And, let's assume that I completed my OPT and STEM extension right now. Now, I want to join a different master's in a different university right now. Do I need to file an I-539 form, or is it in the old system where I just get an admission, transfer the civil system from my STEM extension school to that of the new school?
So there is a restriction on going to school again at the same level, but for people who already graduated from their master's program before September 2026, the old rule still applies. That first master's technically doesn't count, and you can do a second master's without filing an I-539. There's no restriction on that. So if you already graduated before the rule took effect, you still can do a second master's.
Okay.
What
And
about the STEM extension? Processing times are terrible right now. Do they still get the automatic 180-day extension, even if they have to file an I-539 along with it?
that's right. They will still get an automatic extension of the STEM extension of 180 days. But Emily, that rule of working on the automatic extension is only there for STEM extension. It was never there for OPT. You have to wait for the OPT approval before you start working. It is not going to be there in the new regulations. It's not there before too.
So if I am filing my initial OPT after March and I have to include the I-539, do I have to get both approvals before I can start working? The I-539 and the 765?
Yeah, you will have to file it together, Emily. If you're going to file only I-765, they may deny the entire I-765 application. You have to get both of them approval, yes. You can't start without the approval. In the case of STEM extension, you can work up to 180 days when it's pending, but when it comes to the OPT, you have to wait until the approval comes in.
Okay, so if I have already graduated, I have duration of status on my current I-94, I'm finishing my OPT, and now I want to do a 6-year PhD program. I'm going up a degree level. Do I just get a new I-20 now? Do I have to file an I-539 with it, or do I have to file an I-539 later?
Emily, they have given a temporary transition period, which is from September 15, 2026 to March 17, 2027. But they have given a long-term transition period, which is up to September 15, 2030. If you are joining in a program that is expiring, which requires more than September 15, 2030, you have to file an I-539 when you file for it. This is if you're going to move to that university after September 15, 2026. Now, if the PhD, there are some PhDs that you can complete in 3 years. If the PhD, you are going to complete it before September 15th of 2030, though, Since you have a duration of status, the transition period of duration status right now ends at September 15, 2030. The new course that you are seeking, whether it's a master's degree, MBA, or with a PhD, is falling before September 15th of 2030. You don't need to file an I-539 form. But in your case, what you said is that the PhD course is is getting completed after September 15, 2030. You need to file an I-539 form.
Okay, so everybody who's in the US with duration of status has a 4-year transition period till 2030. So if
Right.
my new program can be completed before September 2030, do I need to
Mhm.
file an I-539?
No, you don't need to file an I-539.
Okay, but if it's going to be completed after September 2030, then I need to file an I-539 by September 2030 if I'm joining the program now before September 2026.
Okay, wait. If you're going to join the program, are you going to join the program before September 15, 2026 or after September 15, 2026?
Let's say I'm going to join before because the fall semester is going to start in August.
No new rules are effective before September 15, 2026. So if you're going to join and the coursework is going to get completed after whatever time it is, you don't need to file I-539 right now. However, Emily, the general rule for everybody is that if your coursework is getting completed after September of 2030, though, you need to file an I-539 before September 2030. You don't need to file it right now, but you need to file it afterwards. However, if you're going to join the course after September 15, 2026, and the coursework is getting completed after September 15, 2030, you need to file I-539 before, not later on.
Okay, so if after September 15th, 2026, I want to extend my program, and I get the new I-20 for that. Is that all I need to do? If we're doing it after September 15th, can I just go to my DSO, get a new I-20 like before?
You're speaking of changing the course, changing the university, or what are we speaking right now?
Yeah, if I'm
After,
going to um change, start a new program, let's say, after September 15th.
now, if you're starting a new program, though, the DHS new regulation says that you may have to get the permission from the Department of Homeland Security if you have not completed your degree, but you're changing your program from one university to another university. You have to get the permission of the Department of Homeland Security. The Department of Homeland Security also said that since they may have some issues with implementing this one, they may delay the implementation of this one for up to 2 years, they said it. So we will have to see because they may not have a mechanism. Let's say, for example, you are going to University of Houston, Emily. Now you have not completed your master's degree in University of Houston. Now you want to move to University of Miami. So at, under the current circumstances, you just get a new I-20 from University of Miami. As long as you are in compliance with the current University of Houston, you can just transfer. But from September 15th of 2026, though, the Department of Homeland Security says that you must have some special circumstances to move from one university to another university because you have not completed your coursework in the existing university.
All right. So if I am going to finish my master's degree in May 2027 and I want to
Mhm.
do another master's degree, can I do that?
No, you have to get unless you get a special permission from Department of Homeland Security, since you already completed your master's and that master's you have completed it after September of 2026, though, you cannot just move it to a different university for the master's degree. If you would have completed the master's degree before September of 2026, it would have been not a problem. Since you completed you're saying that you will complete the master's degree after September of 2026, you need special permission and exceptional circumstances for it.
Okay. So just filing an I-539 will not make the second master's possible?
No. You have to get a special permission from the Department of Homeland Security, or you can always go outside the country and get the H-1B stamping outside the country. Let's go to questions, Emily, and see.
Yeah.
I did my. This question is. I did my MS in 2023 and STEM extension in January 2027. If I do masters with and enroll before September 15, 2000, I do not have to file an I-539 form. Do you recommend starting the program now or in January? Either of these situation, you would not require to file I-539, even if you file it in January, or even if you file it right now, as long as your new master's degree program is ending before September of 2030, which assuming that you're going to start the course in January of 2027, your master's program should end in January of 2029 at the most. So you should be fine. You don't need to file I-539 in either of those situations. Now, we in general cannot endorse day one CPT universities, guys. So I just want to tell about that.
All right, this is from TBNS Chandu. He's got STEM extension already valid till January 2027. Wants to know if he starts a PhD, should he start it in January 2027, or does it make sense to start it in August 2026 and forego the end of the STEM OPT? What is the benefit of starting it in August 2026 instead of January 2027? If you started in August 2026, you do not need to file an I-539 right now with starting the PhD. But assuming that PhD program goes beyond September 2030, you will have to file an I-539 in September 2030 at the latest, no matter what. If, however, you want to do this PhD program starting in January 2027, because it's after the new rule takes effect, you would need to file an I-539 to do that, to start in January 2027. So if you start the PhD early, before the rule takes effect, you can avoid filing an I-539 for a little while. Did I get that right, Raul?
I was not following.
Sorry.
I'm not following. I was reading the questions only. The questions with regards to some of these so-called universities, we don't endorse day one CPT universities, but in general, the so-called universities, will the chapter of moving from one master's degree to another master's degree will be completely closed at this point of time? No, because since most of the people have completed their master's degree before September of 2026, though, people can move from one master's degree to another master's degree without, and we'll come back to these questions, Emily. Emily, what are the common reasons why we are seeing that H-1B getting revoked for wage level mismatches? Where is the things happening? I mean, this is all happening when the FDNS is visiting. Tell me where the problems you're seeing, Emily.
Yeah, so the typical scenario is, in the H-1B petition, the company said the job requires a bachelor's degree and 2 years of experience, and they selected wage level 1 or 2 to go along with that. And then the petition gets approved because that is the appropriate wage level for that particular position if it's a job zone 4 occupation category. And then 6 months later, a site visit happens, and when the officer asks, what is the minimum education and experience requirement for this role? Somebody, whether it's the manager, HR, company owner, or the employee themselves, say, oh, well, the job requires a bachelor's and 10 years of experience. Well, now that raises all these red flags, because if the job really does require 10 years of experience, then it's a level 4 prevailing wage and not a level 2. And so they will send a notice of intent to revoke, saying that the LCA does not properly support the petition because it's a level 2 wage when the job is clearly a level 4 wage. That's probably the most common scenario when it's a notice of intent to revoke situation. We see sometimes when nobody knows who the officer talked to, or they maybe talk to someone at the end client, or they talk to someone who was not super familiar with the H-1B requirements in the process. But if indeed the job really does require 10 years of experience or whatever the case may be, the SOC code and the wage level do have to align with that in the petition. They want to make sure that companies are not undercutting US workers' wages by selecting a lower wage level than what's actually required based on the job duties of the position. So that is what we're seeing most commonly. We also see the same issue in request for evidence or notice of intent to deny when the information filled out on the I-129 form does not align with the prevailing wage level mentioned on the LCA. So if on the I-129 form, the employer says this job requires a bachelor's degree, 5 years of experience, and supervises 5 people, that should be a level 4 wage when you're talking about a job zone 4 position. And so if they instead submitted an LCA with a level 2 or level 3 wage, that discrepancy can cause a RFE, notice of intent to deny, and potentially a denial if the employer is not able to explain why that discrepancy exists. Maybe it was a typo, maybe it was a mistake, but if the mistake is on the LCA, you can't go back. There's no backdating an LCA. You can't submit a new one that you obtained after the fact. So that is a big problem to be aware of, but it has to be addressed prior to filing.
We just want to make sure that people understand that what is the job requirement they're asking though. It's, I have 30 years of experience. I mean, is it required for me to do the job of 30 years experience? Not, maybe not. So it's how much the position requires. That's the main thing that's very important there. So just make sure that your supervisor is aware of it, your employer is aware of it, everybody has the H-1B thing. And if there is any disagreement though, you should check with the company's lawyer. The company's lawyer is always very nice guy to deal with compared to the immigration. I guarantee you that.
All right.
Um,
What about these remote work situations? Let's say that my company is located in Houston. I go into the Houston office every day, and now they're going to give me the opportunity to work from home, and my home is also in Houston. Do I need to file an amendment before I can start working from home in Houston?
Absolutely not. Matter of similar solution clearly says that if the job is similar and if the just location is within the same MSA though, and within drivable distance, there's another thing that they have an exception to when things don't fall into the same MSA. So you don't need to file an amendment, Emily, at all. You can work it. Here is where the problem comes in. People think so that when they work from their home, then they are not geographically bound. Let's say, for example, Emily, if you are living in Dallas and your work location in Houston, and you've been traveling weekly here, and all of a sudden now the company says that you can work from home. That's where the major problem comes in. Your home is in Dallas and you're staying in Dallas. That is a violation because according to the LCA regulations, you are only supposed to work in the Houston area. I understand if it's a Galveston, if it's Katy, if it's Sugar Land, if it is Pasadena, Texas. I mean, not Pasadena, California. So all these locations you're fine because they all fall into the MSA of the Houston. Woodlands is fine too. But Dallas, no, it's way far away. It is not drivable distance and you cannot. And oh, I'm working from home. How would anybody know? Well, you guys are the software guys. You guys are writing the software called Palantir and other softwares that you're helping a government out to find out where you are. So there are many ways they can find out your driving license, your thing, where you are. All different things are there. They will come and visit you. I want to visit you. Where are you located at? No. So FDNS visit. So please, if there is anything you need to contact, if there is any violations you already occurred though, I want you guys to contact your immigration lawyer immediately or a private immigration lawyer so that you can find a probably a private immigration lawyer will be much better to find a cure for it. Don't go to FDNS and then don't let the FDNS find out before you have a consultation so that you can try to cure it though. Because here is the problem that comes in. If they found out that you violated the status, it's going to be a major issue because now they will say that your H-1B is revoked. No other company can file a H-1B transfer because you're not in legal status. They have to file in the consular processing. Consular processing, the USCIS issue a love letter, very love letter. They really love you. They just want $100,000 from you. So that's where the problem comes in, is that because of the love that they have towards $100,000 is going to be a problem for you. Previously, we used to resolve it. Yes, get a consular processing, go to India, get the stamping, come back. Right now, $100,000 is a big issue. And there's another issue. There's no stampings available for until August of 2027 or October of 2027.
And I want to add another common situation I see with work from home is when you are working from home in Houston and your Houston address or your company's Houston address is on your LCA and your petition, but then you decide to move to Dallas and work from home from Dallas. Well, just because your previous petition allowed you to work from home doesn't mean you can work from home anywhere your home is. It's only if your home stays in the Houston area. So if you move to a different location that has a different prevailing wage, you need to have an amendment filed before you start working from your new home office once you move. All right, last topic, social media. What are you seeing in terms of visa stamping? Are people facing issues with posts they made years ago on their social media?
Not much, especially for Indian clients, though. I see some Middle Eastern clients definitely are in some soup when they have commented things. But in general, I have not seen. But especially if you're married, make sure, and you're applying for H4, make sure that you document, keep it open though. Make it public. That's better. Let them see that you are married, and make sure that you declare yourself in the married in the social media, because marriage is not a private affair. It is a public thing. You are having a girlfriend, that's fine. You don't have to tell your mom, you don't have to tell your dad. That's perfectly okay. But when you're married, though, it's no longer private information. It is public information. And the person is applying for the H4. You're telling that you're going to hide everything from the society, but when it comes to the immigration, you want them the immigration benefits, but you don't want any of the other things. No, that's not fair. So we don't recommend that at all. So make sure that you publish it. As such, Emily, even though it has been publicized, that I haven't seen any rejections or anything like that on the social media, to my knowledge.
Yeah, I think it's just caused delays more than anything else. Obviously, it was the reason why visa appointments were canceled during the holidays last December. And then the lack of appointment availability is also due to this social media vetting because it takes them more time to review all this information. I've seen a few 221Gs where it takes a little bit of extra time for the visa to be issued once they do that review, but no major delays from the social media nowadays.
Let's go to questions, Emily. I have a question from Praveen Abdul. Both of them have a similar kind of question, so I'm going to add it together. So they're concerned about is traveling an advanced parole. Do you recommend it? Are you seeing any problem? No, we are not. We have not seen any problem with advanced parole. If you want to go to cruise on advanced parole, we don't see any problem with it. If you want to travel to India, we don't see any problem with it. If your 485 is pending, we don't see any problem in traveling on advanced parole.
Neurocheck says, I recently received a notice of intent to rescind from USCIS regarding my green card because my 485 was approved in error because an immigrant visa was actually unavailable at the time of approval. The notice states that if I do not contest it, they will reopen my 485 and adjudicate it again once a visa becomes available. That might be new language that you're seeing. We've had a lot of these issues come up, particularly probably starting in 2022 when there was a rush for officers to approve 485s before the end of the fiscal year. A lot of them, not a lot, but a number of them got approved mistakenly. And it was like pulling teeth to get them to come up with a process for that green card to be returned and the case to be reopened and you to get your EAD benefits back and your AP benefits and all of that. So I'd be curious of the actual language on your notice because that's typically not what we've been seeing, but we had been in contact with USCIS on a number of cases about let's come up with a procedure and policy and make it standardized. So definitely something to, probably consult with one of us if you're not already working with an attorney on that.
One gentleman has completed his master's degree in 2024, and he's going to move to different university planning in early of 2027. Does he need to file an I-539 form? Since you completed your master's degree before September 2026, though, based on the current reading right now, I don't see a need for you to file an I-539 form, assuming that your new master's degree is going to be finished before September of 2030.
Vikas says, last week we said ICE detained someone whose extension was in process during domestic travel. Do you suggest to not travel domestically for people under visa extension with an expired visa? So yeah, in the cases we've been seeing, if the visa stamp is expired and you've got your H-1B extension pending, individuals were detained at the airport by ICE. They were let go, but I've also heard of recent reports of people being detained and not let go, claiming that because the I-94 expired, even though you have an extension filed, that extension does not confer actual status. That extension puts you in a period of authorized stay, but is not actual status. And so they're, holding some people due to that while they figure it all out. So maybe a good idea not to travel domestically, at least by air, until you have your approval notice, which is a ridiculous thing to say. When you are authorized to work, you are authorized to be here, but it's not something I would wish on anyone to be detained. You're going on a trip to visit family or to take a business trip and you end up in ICE detention. That's definitely not something I would want anyone to have to deal with.
News Group Data has this question. Upon re-entry on H-1B, the CBP is asking, have you worked while you're in India? This issue has come up very many times. There are a lot of rumors about it. I have no problem. Yes, if you worked, you worked. If you did not work, you tell them you did not work. Now, there are some people say, oh, you worked on H-1B in India. You don't have an LCA there. You did violated some rumors. People said it, not the CBP. Guys, you are an Indian. An Indian can work in India. You don't need a LCA. You don't need a H-1B. You don't need a green card. You are an Indian citizen. Well, I'm licensed lawyer in India. I'm also licensed lawyer in Texas. I'm also licensed in California, but I'm also licensed in India. As a lawyer of India, I can certify that Indians can work in India. Simple. They don't need immigration. They don't need anything. So if you are in India, if you worked in India remotely, you are not violating. Let me tell you a simple example. You go to Pune, Hinjewadi, you go to high tech city, you go to Bangalore in some of those places. You see all the people working in the night and it's bustling like anything. They are all working, logging into USA. None of them required a work permit. You know why? Because they are sitting in India. They don't need Emily. They don't need Rahul if they're sitting in India. So you're perfectly all right. You can work while you're in India remotely, not a problem. If you don't work, you tell them you did not work. But what they are interested to know is the job still existing when you're entering into the country? If the job is not there, they will not allow you to come into the country. That's the main thing.
Sian says my I-129 and I-539 have been pending for 4 months for a TN and TD extension. I'm assuming maybe a change of status. Can I file adjustment of status and I-140 concurrently while they are pending? I'm EB2 rest of world. Can you? Sure, but should you? Probably not, because that will cause your TN and TD to likely be denied because those categories require non-immigrant intent. And by filing an adjustment of status, that is very clear proof that you intend to permanently reside in the US. The other issue is it depends on whether your previous TN and TD have already expired or not. If they are already expired, then filing a 485 in that situation will likely end up in a denial unless the TN and TD are ultimately approved, but they're not going to be approved if you file a 485, so not the best plan.
Pious gentleman is asking, his friend passed away when 485 is still pending. I'm sorry to hear about it. I mean, it's taking so long. People are not being alive, and that's very sad of it. Now, the question that he's asking is that can his wife still pursue the adjudication? I'm assuming the friend who passed away is the primary applicant. The answer is surprisingly yes. There is a section called 204I section. Sometimes I'm not good in the
I
sections,
think it's
but
L,
maybe it's
maybe.
I, but I'm wrong. I don't remember the section numbers, but for sure, the widows can obtain, and she doesn't need to have a job offer. That's a good part about it. She doesn't have to work for the same company that filed it. She can avail the priority date. She can continue with the 485 application. The only thing is that she has to reside in the United States, which I'm assuming she does. And she can contact our office or any immigration office. They will be able to help her out. Absolutely, she can continue with the thing.
Praneeth says on H4 traveled out of the country in March 2025. At the port of entry, the new I-797 is not showing, and the I-94 was issued as per the old visa, not per the new 797. What are our corrective actions? So this is very common when the new I-797 approval is not set to take effect for several months or even, more than 30 days. A lot of ports of entry will only let you utilize that new I-797 approval when it's you're entering within 10 days of that start date. As far as corrective actions, depends on how long ago this was and the specific situation. It may be something that automatic visa revalidation to Mexico might be a better option, especially if the I-94 is already expired. Filing with USCIS as a renewal is not a great option. We see those commonly denied, even with a non-protunct request, saying that it was an extraordinary circumstance. We didn't know, whatever the case might be. They tend to deny those and then issue a notice to appear in removal. So it's definitely something that does need to be acted on, but you might want to explore automatic visa revalidation instead.
Abhishek is asking the question, if he's an L1, L2 visa people, can they trade the stocks? Is that considered any violation? Absolutely, you can. No problem with it. I'm not a financial advisor. I'm just an immigration advisor. As far as immigration law is concerned, you can. You don't have any problem. Question from Venkat from LinkedIn. That is the first time I'm seeing a LinkedIn getting into this one. Question here. I'm in the process of submitting I-140. Notice my first employment letter has many typos, and there, how can I this be handled? It depends on the typos, Venkat. What do you mean by typo? Is it grammatical typos? What if the typos are that you were, instead of you working until 2020, they put 2010? That definitely is a big issue, though. So definitely, and there's also a requirement. Like, let's say, for example, if the position requires 5 years experience, you already have 5 years experience from some other company, though. You don't even have to present this one. You can use the second companies and still get an I-140 approval. So you have to take a look into it before closely commenting on it. This is from Venkat from LinkedIn.
Abhishek says if an L1 and L2 extension is pending, can one buy and sell stock?
I just
Yeah.
answered
So,
only.
oh, sorry, I missed that.
Yeah. Um,
Meyer
uh,
says, is day one CPT going to go away because of this new rule? How is it going to impact H-1B? Um, so yeah, it does definitely impact day one CPT. I mean, if you've completed let's say you're graduating in May 2027 with your master's degree, and your employer submits you in the lottery and you are not selected, of course, you have your 1 year of OPT time and maybe your 2 years of STEM time. So you can file again in the lottery in 2028, 2029. What if you're not selected all those times? Not most, a lot of people would choose to do a second master's degree at a school that provides day one CPT so that they can continue working for the company and then explore the H-1B the following year because they've run out of OPT time. That is no longer an option. you'd have to do a PhD if you graduated with a master's. If you graduate with a PhD, there's no other option. You cannot, there's no higher level that you can go to after that. So yeah, it does restrict day one CPT going forward for sure.
Kofi Minshap one is asking, wanted to talk about green card bond. Now, I don't know what you mean by green card bond. The only two things that I can know, one is the EB5 green card, which everybody knows that it's a very lengthy period to adjudicate. You can always look into our blogs on what's going on in EB5. You can join our WhatsApp group that we have in EB5 if you want to. But also there is something called gold card, which the Trump has been advertising and saying all those things. That's a delusionary green card. It doesn't exist. It just exists in the mind of Trump. There is no law because the green card has to be given by the Congress, not by the Trump, not by the president. Now, what he's suggesting is that it probably will qualify as one of the things for the national interest waiver or for the EB1 category. One of the items for EB1 requires 10 items. He may be suggesting that this may be included in one of the things, but in general, there is nothing called gold card as what is Trump is advertising.
Ismet says, is there any expected delay or further processing required for those who already applied for a STEM OPT but have not received the approval yet? So if you already applied for it, this new regulation does not require you to do anything extra. But we are seeing significant delays in STEM OPT processing. And remember, you only have 180 days of automatic extension. So if you've already used up 3 or 4 of those months, you need to upgrade to premium processing right away so that you can get your STEM OPT approved within the 30 business days. Otherwise, you're going to run out of the automatic extension and have to stop working.
A gentleman is asking how about the Dropbox for the mom? Will that be approved? There's no Dropbox anymore. So they have closed the Dropbox almost 1 year ago. So there's no Dropbox right now.
Indumati says, I worked for employer A on H-1B, transferred to employer B 35 days ago, and returning to employer A within 60 days. Employer A has not revoked my H-1B. Do I need to file a new transfer or can I rejoin on the old approval? So there's a provision called the dormant H-1B. So just because you got an H-1B approval with employer B does not make employer A's approval go away. It's still there, it's still valid. So as long as you're going back to that company in the same position, same location, same job duties, same salary, everything is the same, then you just go back to work for company A. If anything is changing in that, then they might have to file a transfer or an amendment. But in a lot of situations, you can just go back to employer A as long as that petition is not expired and has not been withdrawn.
Venkat from LinkedIn is suggesting that that his the I-140 letter that he's speaking about, the year of start working is different. Definitely, you need a correction. You can't just submit it because you have said differently in the labor certification. Now you're telling it completely differently. So that need to be corrected. You're saying name. I don't know what name means. If you just Venkata instead of Venkat, maybe that's fine. But if instead of Venkat, your name is Subbarao, then definitely not good at all.
Praveen says, I booked a cruise to the Bahamas quite a while ago. My AP is valid until 2029. Would you advise me to go ahead with the trip? Travel on AP is, knock on wood, one of the safest ways to travel in the current environment under the Trump administration. We've really not seen people have difficulty traveling on an AP, assuming this is, you've got a pending 485 and there's no criminal background, basic employment-based applicant. Generally, we've not experienced issues with people entering on AP.
Emily, have you seen any Dropbox? Reverie is telling there is a Dropbox. I think so. It's probably for above 75 people. Or is the Dropbox still there?
What category? There's just one category that it's still there for, and I can't remember what it is off the top of my head.
Yeah, I can't. Definitely not for B2. He's saying B2 Dropbox, but probably there's an exception for 75 and above people.
Could be.
Emily, any comments on the DMV about the driving license?
It's going to get worse, that's for sure. So, specifically in Texas, the current regulation says to verify your identity, you can use your passport plus a valid or expired visa stamp. And that's been fine all along. Now, all of a sudden, they're claiming that because they're implementing Real ID finally, that the Real ID regulation, federal, requires a valid visa stamp in addition to a valid passport to verify your identity. And that is true. The federal regulation does say that. So Texas is in the process of amending its own regulation to eliminate the expired visa as an option and to only allow a valid passport plus a valid visa stamp in order to get your first Texas driver's license. Um, there's a commenting window and it closes July 26th. So if you are in Texas, you may want to consider commenting on that. I did post a model comment or a template that you can use with instructions on rnlawgroup.com. It's on my X feed as well as LinkedIn. It's going to be very important that we try to get them to either not change the Texas regulation or allow for a separate type of driver's license that is not a Real ID driver's license. Because if you are a foreign national in the US, you should travel domestically. You don't need a Real ID. You have your passport. You either use a passport or a Real ID. So it doesn't make any sense that we're requiring everybody to get a Real ID when not everybody needs it. And the whole purpose of it is just to fly domestically. There are other states that allow for either a Real ID or an alternate that does not have to have these identity issues. California is one of them. But I do think there are other states that are going to join Texas, especially the red states. So this might get worse. We are actively looking at how we can get the federal regulation changed because it is not actually in line with what the Real ID statute says. It's requiring more by saying that you need to have a valid visa stamp. That might require litigation. We're exploring all options there. So stay tuned. But for now, if you are in Texas, what you can do is comment on their proposal to change their regulation to now require valid visa stamps. And it's a little funny because in Texas, they're already following their new regulation that's not actually in place yet. So they are denying people driver's licenses if they don't have a valid visa stamp, suggesting that just go get a visa stamp and you'll be fine. Like that's an easy task nowadays.
Yeah, with regards to B1, B2 visa renewals of the Dropbox in India, though, I will get back to you later on. And also with regards to the 100K green card bond, thank you for letting us know. I will look into it, will comment about it. Probably will do an article on that soon. This is for Kofi Menshep, and you can subscribe to our blog.
IT guy says my recent H-1B transfer approval notice lists an incorrect I-94 number as to what was issued when I entered through the port of entry. How do I get this corrected? So it kind of depends on how the error happened. So if the I-94 number mentioned on your I-129 form is the incorrect number, and that's the one they used on your approval notice, it's not a typo. They won't consider that to be an error. You'll have to either have the company file an amended H-1B petition to get a corrected I-797 approval or travel and re-enter, and you'll get another new I-94 number, and that takes the place of it. Now, if the correct I-94 number was actually on the I-129 form and it was an error from USCIS, which is most likely not the case, but if that is the case, the company needs to request the typographic error correction. You can't do it. Only the company or the company's attorney. If it's premium processing, they can do it by email. If it was regular processing, they have to go through the online service request process or try chatting with Emma or calling customer service. And it's
A
going to take
gentleman,
months.
a gentleman is asking to cover the issue of the age out H4 to F1. I'm going to cover that issue. But one thing is that I really want you to change your name because that name, you're unnecessarily attracting the attention. I don't want to even utter the name that you have it. Please, because it is not good. That name is not good. You're unnecessarily going to attract the attention of other people, the wrong people. Now, coming to the age out of the H4 to F1, when do we want the people to move to F1? We want people to move in at least to have one academic year on F1 visa. The reason why we need to have that is because of some restrictions on OPT and STEM extension. So before you come into third year itself, before you come into the fourth year, we want you to have an F1 visa. And definitely before you touch 21. I don't have to tell you about that. But also leave 1 year gap. And always I recommend people to do it in the after you complete your second year, probably in third year, after first semester, so second semester, that's when I want you to move to F1 because you have 1.5 year, you can do premium processing and you have some time if there is any denial that pops up, you can always rectify it when you have enough time. If you're coming very near to 21, if the F1 is denied after you turn 21, you will be in big trouble. Why would the F1 be denied? Well, here is the reason though. For the F1, you have to prove that once you complete your education, you're going to go to the home country. Now, I don't know whether these kids that you're speaking about who are done high school here, they know what their home country is. And if the denial comes in, then they have to go for stamping out, which is going to be very tough. So probably third year beginning is where I'm thinking is the right time. And before they hit before they hit 20 years, whichever falls earlier, I want you to target that one though. So third year beginning or beginning of 20th year, that's when I want you to hit the F1 visa.
Nomad 10 says, why do you think perm is so strict and lengthy, which doesn't make sense? Why can't they modernize it and improve the timelines? Well, wish granted, because they are planning on modernizing it. They do have that on the agenda for updating the perm regulation process to make it more in line with real world recruiting of how people, find jobs nowadays without newspapers and that sort of thing. But be careful what you wish for because it doesn't mean they're going to improve timelines and they're probably going to make it harder for immigrants, not easier. So, yeah, expect changes in perm maybe in the next year or two.
Odad has this question. The I-94 is expiring earlier. How is the ways that we can extend? Can we file an I-539 to extend? Can we go outside the country? There are a couple of things that we need to know. First is it already expired? If it's already expired, I want you to do one thing. I want you to contact us immediately. If it's already not expired, then there are a couple of other things that you need to look. When is your visa expiring? Is the visa already expired or is visa still there? If the visa stamping is still there and I-94 is not expired, just to go to Mexico and come back, that's easy way to extend it. Or you can file an I-539. That's also is possible for you to do. But it depends on the circumstances. We do have a daily Zoom call, though, where we have more interaction that you can come in. And we do conduct it, we've been doing it from past 14 years, every working day from 2012 to right now, which is 14 years we're doing it. You can join there to ask a question because there we may have more interaction on that thing. It may not require a complete appointment, but interactive session probably would be much better with you.
Naranjan says, do you see any premium processing delays for H-1B extensions? It's been more than 15 business days. I, knock on wood, currently don't have any in that situation, but other attorneys are reporting that is happening. And they're having a difficult time in getting the refund. It's taking a long time and having to follow up a lot. But yes, that is happening. And there's unfortunately not a whole lot that you can do about it other than just wait for the refund of the fee.
My H-1B approval has 1 day gap that is expiring on September 28th and new one starts on September 30th. My employer is refiling the entire H-4 and EAD again. Probably that's a defensive way of doing it. Under the current circumstances, that's a perfect day that they are doing it. I want it to be updated and refiled. This is from Pratish Patel from LinkedIn. We're getting new questions from LinkedIn. That's very nice.
Um, CS Petnick says, currently both home and office are in Tampa. If I wish to move to Orlando, which is 100 miles away from Tampa, is an amendment required to file? Note that I'm required to work 2 to 3 days from the Tampa office. Most likely, yes. I believe Orlando is in a different MSA from Tampa. There's going to be a different prevailing wage. The company will have to pay the higher of the two prevailing wages. And they will need to list both work locations on your LCA and amended I-129 petition, since you also will work 2 to 3 days from Tampa going back and forth.
Item Power King is asking the question, how are the EB1 approval denial trends for tech professionals with 10 to 15 years experience? Experience, I'm not that impressed with experience, though. I want something spectacular from you, though. Experience is you're just telling I'm old. No, that's not good enough. So please tell me something different. Definitely EB1A approval ratings have gone down significantly. Previously, when you are qualified for out of the 10, if you qualify for three of those requirements, which are, everybody knows what those 10 requirements are, then you would be given the EB1 I-140 approval. However, USCIS is now coming up with the saying that what is the impact on the society? Because you having those qualified three or four of those things, what is the impact on the society is what they're looking into more right now.
Rockstar says H4 is pending since October 2025. How do we speed up the process? Yeah, that is common. For an H4, it may not be necessary to speed up the process because you are authorized to stay in the US the entire time that application is pending, whether it's an extension or a change of status, even if the I-94 has expired, as long as it was timely filed. But if you do, for some reason, need to speed up the process, really the only option is litigation.
The gentleman who asked the question of L1, L2 trading stocks, he's asking question. He's actually L1A, L1 and L2 extension is pending. Can he trade the stocks right now? Absolutely not a problem. Absolutely not a problem. You can trade stocks when you're on B2, you can trade stocks on H1B, you can trade stocks on L1, L2, H1, H4. Even if you don't have an employment authorization, you can trade the stocks. It's considered to be investment, though. It's not considered to be working. Investment is allowed in USA. Absolutely not a problem. Anything else, Emily?
Looks like we are out of time for today. Thanks everyone for joining us. Again, we do have that daily Zoom call that you can join to ask your questions and interact more about your specific situation. So you can go to rnlawgroup.com to get the details of how to log into that.